Hey, everybody. Today I'm going to talk to you about American constitutional rights. First of all, welcome to Law and Society. Please subscribe. Secondly, I want to shout out to somebody who commented on the short section that I had missed out parts of the Bill of Rights when talking about constitutional rights. In my defense, those were the short videos that were 2-minute increments. So I couldn't really go into the specifics of every single amendment. And that's what I'm going to work and do this time around. So to begin with, the Constitution of the United States does not vest to its citizens any rights. The Constitution of the United States forms the government of the United States, the legislature, the executive branch, the judiciary. Then it gives instructions on how elections are to be held. It gives instructions on how amendments are to be brought up in Congress and then ratified by the states, but it doesn't give any individual rights. So about 2 years after the U.S. Constitution goes into effect, a Bill of Rights is passed by Congress and ratified by the states. And the Bill of Rights, Amendments 1 through 10, are the basic constitutional rights, individual constitutional rights, and some associative rights that fall on the people. Rights that the government will respect and rights that the government will not trample over. And then outside of the Bill of Rights, there's the 13th Amendment, the 14th Amendment, and the 19th Amendment. So I will go through these amendments and talk about the written rights in the Bill of Rights, and then remind you of the 13th Amendment, the 14th Amendment, and the 19th Amendments. The 13th, abolishing slavery, the 14th, Section 1 of it, talking about Equal Protection Clause and due process that states have to vest and have to give to citizens and not just the federal government. And the 19th Amendment is about women's suffrage, right to vote based on sex. So let me start out with a Bill of Rights. The First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So at the very outset, the Bill of Rights, the First Amendment says that the government, that Congress can make no law that respects an establishment of a state religion or prohibit the free exercise of religion. This was an important thing at that time because the different denominations of Christians who had come to the United States from Europe had been fighting amongst themselves in Europe. And so it became important for our founding fathers to say that we are going to respect all religion and let them flourish. And the way to make sure that we do that is to not allow the government to go in and give preferential treatment to one religious sect over another. And that is sort of ballooned now into an America which includes every religion virtually that is in the world. There's somebody of every faith in the United States, which makes the freedom of religion that much more important. And these attempts by certain states and the federal government officials talking about religion and God in the context of state is prohibited by the First Amendment. It also prohibits the government from abridging our freedom of speech, which is a broad right. And you have various legal precedents coming out of the Supreme Court that supports the freedom of speech body of law that really gives Americans a wide berth of what can be said and still be protected under the freedom of speech. And of course, there are limits to freedom of speech. There are limitations to it dependent on whether it incites danger or incites violence. It depends on the imminence of the violence and the intention of the person, and the person knowing that this type of incitement would cause that type of a dangerous, harmful situation. That's the Brandenburg test by the Supreme Court that talks about your freedom of speech limitations. It's not one of the things that we learn about all of our rights is that they are not unfettered right. There are limitations. Like in the freedom of speech, you can't go anywhere and start yelling and speaking without being removed. And the reason why authorities have the right to remove is because there's such a doctrine known as the time, place, manner doctrine. The time, place, manner doctrine says that the government can designate the time, place, and manner in which you express your freedom of speech in any area that is a public property, yet you don't have the proper permit to be able to protest. So that has grown over time to be able to provide certain guardrails so the government can, in some instances, for the sake of maintenance of peace and for law and order, provide these guardrails of speech. Like there is the exceptions to speech, and then there are the guardrails of what amounts to incitement, and the idea of when, where, and how you can go about your freedom of speech is something that our Supreme Court has interpreted as something that is allowed by the Constitution and not forbidden by it. Then there's the there's the freedom of the press. The freedom of the press is critical to every democratic institution. And so our Constitution, the Bill of Rights to the Constitution, the very first amendment, says that the government will not abridge the press. Something that we are seeing happen before our eyes over and over and over again by Donald Trump's regime. And it's important to remember that the government's impingement and abridging of the freedom of press is forbidden by the First Amendment. And I wish more of the press were to pick up the Constitution and show up with the Constitution and say, we have a right to be here. And I believe that the freedom of the press at this time, in this age, has to include the freedom to access areas that the press needs to get information from. So there has to be a limitation put on what the executive can forbid in terms of taking away press credentials. That's something that we need to think about. That's the type of regulation that we need. We don't need any sort of regulation to censor the press. We need to find a way in which the press can be present at the location and get the information directly from the Pentagon, as well as from the White House and any other governmental organization, department, without the government having the power to remove them absent just cause or absent some criminality. And that's something that we need to think about when the next Congress and the next administration comes in. The right of the people peaceably to assemble and to petition the government for a redress of grievances. This is the right for us to peaceful protest. Peaceful protest gives us the right to assemble and petition the government for a redress of grievances. Whether we do that informally or formally, we have a right to gather So there's an associational right here that is not written down, but the right of people to peaceably assemble includes the right to assimilate, the right to associate, and the right to petition the government for a redress of grievances is a statement that allows you to express yourself, to let the government know what the grievances are. So these are the basic core written rights of individuals out of the First Amendment of the Bill of Rights of the Constitution. You will notice that I have said that there are certain associational rights, certain privacy elements, as we will go through the other rights, that are going to be important when I talk to you about the unwritten constitutional rights. So then there's a Second Amendment. The Second Amendment says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This is a very controversial constitutional right, but it is very clear that there is a right for the sake of a free state to have a well-regulated militia. And we have that well-regulated militia now with the National Guard system in all of the states. In addition to that, because when this was written, the militias would be called up from the people. There was no organizational aspect to a state militia. So there was an individual right, which still stands today, the right of the people to keep and bear arms. And the government cannot stop that. It is a vested right of every American citizen to keep and bear arms. Mind you, this is a defensive right. This is a privacy right, because how and when would you use it? For the sake of necessary security. The right of the people for the security of a free state and for the people to keep and bear arms. It is a defensive right. It doesn't say the right to shoot somebody. It says the right to bear arms and keep arms in case that you need it for your property rights. If they are being harmed, you have a right to protect your property, because the core of our constitutional construct comes from the due process of law for property rights. Life, liberty, and property are the primary object of how American law has developed. The pursuit of happiness is I believe, a sort of flowery way of saying property, to pursue whatever ends you may want to go to acquire property within the law. And so the right of the people to defend their property is essential to a functioning society. And that's what the Second Amendment encompasses. Related to the Second Amendment is also the Third Amendment, that includes the privacy of the home, where it says no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner prescribed by law. So during the Revolutionary War and afterwards, there was this idea that military people, when they were deployed, they would be housed in people's homes. And that caused a lot of problems with the safety of women, with the safety of the property of the people who were letting these other militia stay with them, the soldiers stay at their house. And so the Third Amendment right says the government cannot force you to have the military in your home at a time of peace and even at a time of war unless prescribed by law. Okay? Then we go to the Fourth Amendment. The Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So this is a big privacy amendment. The Fourth Amendment talks about individual security of people in their homes, of their belongings, and the prohibition of the government from unreasonable searches and seizures. And in order for you to search and seize a person's house, not a citizen's, mind you, a person's house, papers, effects, against unreasonable search and seizure, you have to show probable cause under oath based on particular place to be searched and person to be seized. And over the years, with the Terry line of cases in late 70s, early 80s, the Supreme Court has worn this right down to a point of saying that in cases of immigration, for example, something that is relevant now, you don't have to reach the level of probable cause to stop somebody or seize a person. You only need particularized and articulable facts that give you a reasonable suspicion based on your knowledge and these particular and articulable facts that there is illegal immigration or illegal immigrants at that place. But in the Terry versus Ohio line of cases, it was about whether a police officer can look at you and assess you and stop you without anything else but a suspicion. That suspicion had to be reasonable, the Supreme Court said. And thereby, it eroded away at the necessity for probable cause. When you are outside, when you are outdoors, okay? When you are on public property, the Fourth Amendment and probable cause requirements still apply very much to the federal government or agents of the federal government or states to come into your domicile to be able to break in without a warrant, as it says. You need a warrant based on probable cause in order to search a place or to seize a person who is staying at that place and who is inside a dwelling which that person considers to be their domicile. So the Fourth Amendment is a very important privacy amendment from which privacy rights arise of securing our houses, our papers, our effects, our belongings, our property from unreasonable searches and seizures. Something that we really, really need to hone in on and remember when we are seeing what Donald Trump is doing now with the excuse of ICE immigration. The beginning of their inquiry begins with reasonable suspicion and not probable cause. So at the outset, they are already crossing over the Fourth Amendment requirement because they're not only going after immigrants, they're also going after homeless people, people they consider mentally ill. They're going after people who they consider Antifa, who consider themselves anti-fascists, and creating the possibility of them becoming designated as domestic terrorists. And there is no showing that these people can be seized, but still they are being seized on the basis of reasonable suspicion and denied what we are going to see in the Fifth Amendment of due process of law. And that is unconstitutional based on the fact that these are unreasonable seizures. And when they're breaking into homes, those are unreasonable searches. Those are invasion of privacy based on the Fourth Amendment. And we are seeing that happen right now, or we're seeing the slippery slope of them taking reasonable suspicion and making that the centerpiece of what the government needs to break into your home and to be able to seize you, when that is not the standard. The standard for inside somebody's home is still the Fourth Amendment's probable cause requirement. And only in certain situations does reasonable suspicion come in, like immigration, or like crime prevention in areas that are heavily ridden with drugs, because drugs were the impetus of why the Terry versus Ohio line of cases came about. So that is out the Fourth Amendment right against unreasonable search and seizure. Me giving you a full, not even, this is not full, this is still a very, very brief idea of what these rights are. There are hundreds of cases, dozens of Supreme Court rulings that sort of weigh on either sides of the privacy element that comes out of the Bill of Rights. And the Fourth Amendment is a big privacy right. The Fifth Amendment, which we're going to go into now, is about due process. And it is about your infringement of your bodily autonomy. No person shall be, and I'm going to read the amendment and go through it. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subjected for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. So that's a big, big amendment. So let's break it down. No person shall be held for a capital or other crime unless they have been indicted by a grand jury. Unless you're in the military and their military law applies over there. No person, nor shall any person be subjected to the same offense to be twice put in jeopardy of life or limb. That is the double jeopardy clause. It means that, say for example, you have been tried and acquitted for murder under federal law in a particular case for murdering one particular person. You have been acquitted for it. You cannot be subjected again by the federal government based on that statute for killing that person that you were alleged to have killed, but then you were acquitted for. For that particular murder, that particular victim, that particular law that is federal, you cannot be sued for it again. This does not preclude the state from prosecuting you for state murder charges based on state crimes, state laws. You can be prosecuted under state law, and that may turn out that you were convicted. And that would fall under state law. That's not double jeopardy. But double jeopardy applies when you are in a jurisdiction, that in the same jurisdiction on the same case that has already been adjudicated. You cannot be prosecuted for that all over again. Nor shall be compelled in any criminal case to be witness against himself. That is the right against self-incrimination that comes out of the Fifth Amendment. It is a right of choice to not say anything. That's why in the seminal case that is a landmark case is, I think it's Miranda v. Arizona, or it's Mirandizing. When you hear about Miranda rights, one of the first is you have a right to remain silent. And that comes from this idea that in a criminal case, you cannot be compelled to provide witness against yourself, therefore confess to your crime or be coerced into confession. And so you have the right against self-incrimination, and therefore you can invoke that right, say when you are even standing in court and you are asked a question where you feel you saying something would incriminate you for having committed any crime. You can plead the Fifth, and that is a full stop for any sort of other governmental inquiry. And the Fifth Amendment right comes into effect when you have already been arrested under some charge that's based on probable cause from the Fourth Amendment. And then that probable cause charge is then presented as an indictment by a grand jury. And then you get to the point where you have the right to not speak against yourself. So it's categorically going into the privacy of a person to keep themselves safe, even in an instance where they themselves may think that they have committed a crime. The Constitution says you have a right to not say anything about that. Remember that. But that doesn't mean you can go around committing crimes and then saying, I invoke the right to Fifth Amendment. There are other other ways of proving that you have committed a crime than for you to confess to the crime. That's why there are trials. That's why there are evidentiary hearings. That's why there are depositions. That's why there are, the trial procedure happening. And then there's the jury coming down with the verdict. So then it says, nor be deprived of life, liberty, or property without due process of law. That is what we call our right against being held without due process of law. So if you are being deprived of due process of law, that includes you being deprived of your life, your liberty, or your property without the government providing you with notice, without the government providing you with whatever sort of seizure document that they need based on probable cause, based on any standard. Deprivation of your rights without due process of law is what the Fifth Amendment's due process clause prohibits. And it vests onto citizens the right against being held without due process of law. And let me just clarify that. It's not just citizens. It's persons. Okay? So clarify, no person. It's over and over again. It is about persons in the Constitution. It doesn't talk, in the Bill of Rights, it doesn't talk about citizens. So no person shall be deprived of life, liberty, or property without due process of law. That includes the detainees who are now in the dozens of detention centers all around the United States. Nor shall private property be taken for public use without just compensation. I think that's an element of government commandeering your property, condemning, not commandeering, condemning your property. There's a whole nother body of law about that. And it pretty much says that, the government cannot infringe on your property rights and take away your property for public use without just compensation. They have to pay you. They cannot take away your property. So the Fifth Amendment, as you can see, comes up with a lot more rights that guard against the government overreaching into the individual's life space, or even in the individual's autonomy to choose to remain quiet. The individual's right to not be subjected to harassment by the state by prosecuting over and over again for the state for the same crime. The government cannot deprive you of your fundamental liberties of life, liberty, and property, fundamental rights of life, liberty, and property without due process of law, without notice, without a complaint, without any sort of judicial process, any sort of process, whether that be arbitration or whether that be as prescribed by law. You are due process of the law. Okay. The Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process of obtaining witnesses in his favor, and the assistance of counsel for his defense. So this tags along with the Fifth Amendment rights of what other protections that you get if you are being criminally prosecuted by the state. You are entitled to a speedy trial, a public trial. You are entitled, it is your right to have a jury trial. At every judicial proceeding, every court proceeding where there is the state that is prosecuting a case against the defendant, they are always given the right, they're always presented with either the right to jury or trial by judge, which is called a bench trial. And that's because we have the right to an impartial jury and a public right to a speedy trial. What speedy trial means is entirely interpreted by the judiciary. So, where it is going to happen that they are informed about the nature of the accusations, that they are confronted by witnesses, they have the right to be, and they have the right to confront their accuser, and they have the right to bring their witnesses, and all of this is girded by the right to have the assistance of counsel for their defense. That's why part of Miranda rights is that you have the right to an attorney. You cannot be deprived of your right to attorney unless you waive your right to an attorney. You can not be deprived of your right to a jury trial in criminal cases where you have a right that has not been waived. But you can waive that right. You can go to a bench trial. You can incriminate yourself if you want, despite the Fifth Amendment giving you the right to stay silent. These are choice elements that come out of the Bill of Rights. The Seventh Amendment. This is about civil cases. In suits at common law, where the value in controversy shall exceed $20, the right to a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. So it talks about fact-finding courts having the jury finding the facts of the case, and the jury having the power of deciding whether somebody is liable or is not liable in cases involving exceeding $20. That's still the case, and so Seventh Amendment preserves your right to a civil trial and a jury trial, and then the jury verdict and the facts in the jury verdict not be altered by any other court. So the fact finder is the jury in a case where you have a jury trial. In the case if you choose a bench trial and it's a civil trial, then the judge's order is the last word. It's because you have waived your jury trial right, and you have said the judge can speak in place of the jury and be the fact finder as opposed to a jury. The Eighth Amendment says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So this is the right that we have against the government subjecting us to cruel and unusual punishment, or to assign bail at an excessive amount, and that is varied from jurisdiction to jurisdiction of what they consider to be excessive. But the the U.S. Constitution Bill of Rights says that you cannot be the bail cannot be excessive, the fines cannot be excessive, and so the laws are determined based on the legislature determining what is the right amount and what is the maximum amount, and even sometimes what is the minimum amount that the liability should be. And whatever the liability is, you cannot be subjected to cruel and unusual punishments. Now coming to the Ninth Amendment. This is an important amendment because it is a critical amendment for the unwritten rights that the Constitution vests according to a body of law known as substantive due process. And I'll talk about that soon after talking about these last few amendments. The Ninth Amendment says the enumeration in the Constitution of certain rights, so the enumeration, the written down, the explicit nature of certain rights shall not be construed to deny or disparage others retained by the people. So, because the Constitution has certain rights written down, does not imply that other rights retained by the people are denied or disparaged. This opens up the Constitution and the amendments to that will follow, in which individuals are granted more rights that is not vested in the Constitution explicitly or in the Bill of Rights. The 10th Amendment says, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So the 10th Amendment is states' rights. This is the basic framework of the law, the Constitution and the amendments to the Constitution. That is the basic framework on which every state needs to operate. They cannot deprive of federal rights or go against the federal Constitution. Now, they can, however, build a legal body of law in areas that the U.S. Constitution does not delegate to the U.S. government, to the federal government, or it doesn't explicitly prohibit from giving it to the states. Those rights go to the states. And the clearest power that comes up in mind is the police power, the state's police power. The state's laws, that the reason why I talked about double jeopardy in federal court and in state court is because there are two different set of laws. One is federal, the other is state. And that is because state policing power is one power under the 10th Amendment that is not prohibited by the Constitution and not vested to the federal government, the responsibility of policing the states, that the states have the power to police and enact laws that will police for crimes that are state crimes, that the state constitution considers to be state crimes, and that are not in conflict with the federal constitution or federal laws. So these are the Bill of Rights. Then there's the 13th Amendment that says neither slavery nor involuntary servitude, except as a punishment for crimes whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. And Congress shall have the power to enforce this article by appropriate legislation. That's why this is the law that pretty much frees the slaves, abolishes slavery, except in the case of you being punished to do so. And I believe that that issue is still being sort of talked about in the courts, about whether servitude is something that the states or the federal government can subject you to if you are incarcerated for a crime. I don't know if it's conclusive yet about what's happening, what the state is with that, but the 13th Amendment abolishes slavery. That's the important chunk of the 13th Amendment. The 14th Amendment is long, and there are several sections of it, but the section that is important for us to read in terms of individual rights is the first section. And this applies to the states, as you will see. And by way of the 14th Amendment, the legislature at the time, and then ratified by the states, says that the states also have a responsibility of abiding by the due process of law. So it says, the section 1 of the 14th Amendment says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That is the birthright citizenship clause. If you are born in the United States, you are subject to the jurisdiction of the United States. You are a citizen of the United States. That was intended to be able to say that if you are born, if you were born enslaved, you are a citizen of the United States because you were born in the United States. And it has gone, and the court in many, many cases has interpreted this particular birthright citizenship clause to apply to anybody who has been born in the United States, not just in the racial context, in the African American context of our history, but everybody who is born in the United States is a citizen of the United States. And it says, no state shall make or enforce any law that shall abridge the privileges or immunities of citizens of the United States. So it essentially tells, enunciatedly, the states cannot deprive the people of the rights of being citizen of the United States. So the Bill of Rights applies to every single citizen of your state. Nor shall any state deprive any person of life, liberty, or property without due process of law. So the Fifth Amendment prohibits the federal government from depriving any person of life, liberty, or life, liberty, or property without due process of law. The due process clause of the 14th Amendment brings that to the states, saying that no state can deprive a person of life, liberty, or property without due process of law, nor deny any persons within its jurisdiction the equal protection of the laws. That is the equal protection clause of the 14th Amendment that applies to state discrimination against citizens based on the protections provided by the Constitution. And then you have the 19th Amendment, that is, the right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of sex. So that is women's right to vote. Now I will talk to you about unwritten constitutional rights. So remember how the Ninth Amendment, and I'll read it again, the Ninth Amendment says, the enumeration in the Constitution, meaning the written out explicit rights in the Constitution of certain rights, the rights that are provided, shall not be construed to deny or disparage others retained by the people. So the people may have other fundamental rights that are not enunciated in the Constitution. And then there's the 14th Amendment that applies the Bill of Rights along with the 9th and 10th Amendment to state governments as well, that state governments cannot abridge constitutional rights that are not enumerated in the Constitution. So Griswold v. Connecticut, a case that was, I think, came out in 1965, it is a case that sets up this body of law called the substantive due process body of law. The substantive due process body of law actually comes from a set of cases, 50, 60 years before Griswold v. Connecticut, in a contract cases called the Lochner era cases, where the Supreme Court talked about unwritten rights that individuals and citizens of the United States have. So that concept of unwritten rights is now in Griswold v. Connecticut by the Supreme Court, saying that based on the Bill of Rights and the choice and privacy elements that are encompassed in the First Amendment, in the Fifth Amendment, in the Fourth Amendment, in the Second Amendment, your choice, and even in the Third Amendment, your choice in the Sixth Amendment, these choice, that your right to choose, your right to privacy, creates a penumbra, a shadow of other rights that are not enumerated but cannot be denied to the people based on the Ninth Amendment. And that includes your associational right, your right to associate with who you want to associate with, your right to express, part of the First Amendment, but doesn't explicitly say so. Your right to speech and how you, your right to speech in the context of your association of where you're speaking, your organizational rights, your family rights, your right to same-sex marriage, right to bodily autonomy of whether to choose what to do with your body, from which Roe versus Wade came, and then Dobbs overruled Roe versus Wade. But even now, with Dobbs, the government is required to provide a legitimate state interest to stop an abortion from taking place, and has to show that there is no harm being done to the other person to the defendant, or to the mother in the case of abortion, it is the right to choose whether or not to terminate your pregnancy. It's a choice right. It's a privacy right. It's a bodily autonomy right. It's not written in the Constitution, but it is still considered a right for which the government has to give a legitimate state interest in order to draft that law. So there's, for example, that's why laws that are complete bans with no exceptions to the health of the mother and other exceptions like rape and incest, is because there's no state legitimate interest in promoting rape or incest. There is no legitimate state interest in having the life of the mother be terminated to keep the fetus alive. So that is where this unwritten law called the substantive due process of law keeps sloshing around. And this Supreme Court is the first Supreme Court since Griswold v. Connecticut was the first Supreme Court to vest these unwritten rights on the people on the basis of the Bill of Rights, the 9th Amendment and the 14th Amendment, whereas Dobbs pushes the government back and says, no, there is no federal constitutional right. We are pushing it to the states. There's no enumerated right, and doesn't accept the argument of the penumbral rights theory that goes into see whether there has been in our history and tradition cases of a particular right being exercised, or a particular right being deprived, or if there are in our history and tradition this tradition of ordered liberty that certain marginalized populations, certain people who have been historically marginalized, are put in a protected class. And that could include anything from sex discrimination, to sexual orientation discrimination. And those are rights that are not enunciated and could be taken away by the Supreme Court at any time. That's why the right to same-sex marriage is under threat. The right to contraceptives is under threat. The right to family rights is under threat. And I'll end with this. The critique of me that got me to this hour-long episode explaining to you what the Bill of Rights are, talked about a lot of flair in the First Amendment. Well, the First Amendment has a lot of flair in it because it talks a lot about individual autonomy and choice and the right of freedom of speech and expression. And then the other rights talk about your privacy and your autonomy, your bodily autonomy of not being seized by the government. And all of these rights come together and they condense in a sort of an umbrella of rights that includes certain privacy rights that are not enunciated in the Constitution. And that is a substantive due process body of law. And that is what is under threat because it is not penned in the Constitution or by way of an amendment that you cannot discriminate on the basis of sex or sexual orientation or who you associate with or your family or any sort of racial discrimination that happens. And then that state laws that violate racial laws, discriminatory laws on the basis of race, these all come up through the First to the 10th and then the 14th Amendment. So it is important for us to look at the unwritten rights as well as the written rights. And when we look at the written rights, we should pay attention to the privacy and uh, the bodily autonomy elements that come into play with every successive right that protects the individual against state oppression in the 14th Amendment. And then when I say state, I mean federal government oppression under the Bill of Rights. With that said, I've talked for about 50 minutes now. This would be considered a class lecture on the Bill of Rights. And, you know, if you have any other questions about it, please put them in the comment box. If you have a critique of how fast I've gone about it, I apologize. If you want me to do a deep dive of every single amendment, I would ask for you to leave that request in the comment box. I will think about it. It's not impossible to do, but it is a lot of research for every single amendment to be able to give you, for example, anything from the Brandenburg test in First Amendment context to Fourth Amendment Terry v. Terry v. Ohio line of cases, or then you go into the substantive due process with Griswold v. Connecticut line of cases. And so and 14th Amendment cases are everywhere. So if you want me to go through them, let me know and I will get on that mission. Cannot promise it being a prompt request that will be fulfilled, but I will do my best. And with that said, thank you so much for putting up with me for this long. I'm surprised that I have put up with me for this long. So thank you. Please remember to like, share, and subscribe, and I'll talk to you soon.